Hello, it's a pleasure to be with you here today. I am attorney Christopher Nudo, and I serve the Chicago community, specifically with offices in Arlington Heights and Elgin, Illinois. My practice focuses mainly on estate planning, real estate, and business transaction law, which is essentially the support of businesses from the legal community. Today, I am going to address the benefits and the nuances that entrepreneurs and business owners should consider when doing their estate plan and how their estate plan is interwoven with their business. So, let me give you a little background on why this topic was so important for me today. Many self-employed professionals seek the same guidance as regular W-2 employees with regard to estate planning, but yet there are a number of distinctions, those of which we're going to go over today, that I want business owners to be aware of and take advantage of the different planning techniques that are available. A lot of questions revolve around whether or not you are a corporation, a partnership, and a limited liability company, or just a sole proprietor. And we are going to try and touch on all of those as we go through our material today. So let's jump right in and talk about what our agenda is going to look like for the day. We're going to talk about how estate planning and financial planning differ for the self-employed professional, because often people will confuse financial planning and estate planning, and while they're for sure interwoven, they are different. We're going to talk about when it makes sense to form a separate entity like a limited liability company or a corporation. We're going to touch on how a trust can own these entities and why it is important. If there's any tax advantages, we're going to touch on those. And what types of investments make sense. And by far, I'm going to tell you that the investment part of this talk today is going to be extremely limited because I am not an investment advisor, but I will tell you from personal experience how certain investments with a self-employed person like myself for estate planning and how the different vehicles that we've taken advantage of impact what we do. So how about we jump right in, shall we? So first of all, how does estate planning differ from financial planning? Well, first of all, estate planning is the endeavor to plan for when you're going to die. So you are either a single person or you're married and you are going to die someday. And I know that as a certainty. And so when you die, what happens? And if you own your own business, when you die, what happens to that business? But let's go one step further. Estate planning also can be about planning for what happens if you become disabled. Many people today suffer from debilitating incapacities such as dementia or Alzheimer's before they die, and they can't manage their business. So how does that, or I should say, that is also part of the estate planning process. Now, similarly, yet different, financial planning is about looking at what assets you have and looking at your financial net worth and looking at your risk aversion and looking at your continued earning capacity and a number of other things, and deciding how today should your estate look from an investment outlook. Note, they're similar, but yet very different. Financial planners, I am not a financial planner. I do not sell you investments. I do not suggest investments. I do not look at your portfolio and assess whether or not you're invested properly. My job is to look at what does your investment portfolio look like today, and what do other assets that you own look like, including your small business, and when you die, what's going to happen to it, and how will that impact your children or your heirs or your favorite charity that you want to bless. So all of this, by the way, is very different than the W-2 employee. The W-2 employee goes to work, receives a paycheck, and having to plan for the succession or the winding up of their small business doesn't exist. Where a small business owner might have employees, have vendor relationships, have continuing contracts with clientele. And so those things need to be addressed when they die. So what I want to say today regarding estate planning and the small business owner is we need to first look at what you have. If you come to me as a sole proprietor, that's fine. That's easy. That means there's no entity. And so the way we treat you is the way we're going to treat your estate. So if I'm meeting with you and I suggest that a living trust is the proper planning tool to ensure that your estate transfers nice and easily to your heirs without probate and privately and quick and efficiently and without a lot of cost, then whatever I've done for you will also apply to your small business. Now you come to me and say, but Chris, I am a corporation. As a matter of fact, I'm an S corporation. And let me tell you, for purposes of today's conversation, there's no distinction between an S corporation and a C corporation from an estate planning perspective. Now, I understand there are many distinctions between the two entities, and an accountant would have lots to say about the pros and cons, benefits and burdens, and all of the things between a C Corp and an S Corp. But for purposes of this discussion today, there is no distinction, because a corporation is made up of its shareholders, directors, and officers. The shareholders of a corporation are the owners of a corporation. And entrepreneurs, most entrepreneurs, like 99.9% of them, are small business owners who own their 100% of their company. And it's very common for husband and wives to own the company together, or they own it with their best friends. And so as it relates to estate planning, what we want to do is make sure that the ownership of the corporation is properly held or titled in the name of the trust for your family. Thereby, upon your death, that stock transfers to your beneficiaries under the terms of your trust. Now, there are some particular instances where you cannot have shares of a small corporation held by a trust, such as doctors. Doctors who own medical practices. The state of Illinois says that only licensed physicians can be the owner of, I believe, 90% of the stock. I believe 10% or less, or some very small percentage, can be owned. It might be 5% now that I'm thinking about it, can be owned by a non-licensed physician. So Mr. and Mrs., or I should say Dr. and Mrs., or Dr. and Mr., so I want to be politically correct, come to my office and they sit down and they say, he or she, doctor, owns their own medical practice. They want to do a living trust estate plan because, again, they want their estate to avoid probate, be very simple for their children when they die, avoid probate, and have it cost very little money. So they say, what do we do with the doctor's practice? And I say, we create a stock certificate that says doctor owns the stock, TOD, transfer on death to either the surviving spouse or their living trust. And in most instances, it's going to be their living trust. Now you say, but Chris, as soon as the doctor dies and it transfers to the living trust, aren't you violating Illinois law because the living trust does not own is not a licensed physician? And I would say, you're right. But the medical community has thought this through. And what they say is there is a period of 1 year where a non-licensed physician can own the shares of a medical practice if in that time frame they are making an effort towards either selling the practice or winding it up and shutting it down, so that at the end of the year, a licensed physician either will own the practice or the practice will cease to exist. Okay, so we talked about corporations and the fact that we would have to make sure that the shareholders of the corporation either have a transfer on death designation or are retitled in the name of the family trust. What if you have a limited liability company? Well, it's very similar. As we know with limited liability companies, they don't have shareholders. They have members. Now, members today are very much like shareholders from an ownership standpoint. They are actually very different depending on how your limited liability company is structured. But for purposes of today's conversation, if you own limited liability companies, and the most common is the real estate investor. People come in, they own a number of rental properties. The rental properties are held by individual limited liability companies, and they want to make sure that the clients want to make sure that upon their death, their investments in these limited liability companies get properly transferred to their children. And the answer is we assign the membership interest of the limited liability company from the client as an individual to their trust. So then their trust owns the interest in the limited liability company. In both of these situations, the limited liability company and the corporation, the client keeps all the benefits of the entity they have and receives the benefit of when they die, their entity is properly transferred to their heirs, avoiding probate, and it's done in a very quick and inexpensive fashion. Okay. So we kind of touched on our next topic, which was what types of assets can be owned by a limited liability company or a corporation associated with a trust? So we're going to kind of keep moving. I didn't realize I kind of blended those together, which is very cool. So we can move on to the next topic, which is what tax advantages come from certain types of estate plan structures and trusts. Okay. This is a very, very lengthy topic, and we're not going to dive super deep in it. We're going to stay right on the surface of it. So there are lots of different trusts that can create many different tax advantage structures. A lot of them require that is a husband and wife, but there are charitable means in which we can take advantage of taxes, and there's different gifting strategies. But let's talk about how does this relate to the business owner, because that's kind of the overarching topic of today's conversation. And one of the things that business owners should be taking advantage of is expensing usual and customary expenses in their business, and per the Internal Revenue Code. And so when your living trust owns your business, you are allowed to continue taking advantage of these business expense deductions, which reduce income to your entity. And there are benefits to different trust setups, one being individual trusts versus joint trusts. Now, most of the clientele that I sit with qualifies or fits nicely into what's called a joint trust. A joint trust is one trust for husband and wife. And the reason I like the joint trust is because it really mimics the husband and wife relationship very well. Husband and wives tend to blend all of their assets together as one, and they treat the assets as one owned by two people. A joint trust accomplishes that same goal. However, it doesn't always work nicely with business owners, because if the wife is the business owner and the husband is the W-2 employee, not necessarily working for the wife in this illustration, then what we like to do is set up individual trusts, because we like to take the wife's business and keep it separate from the other assets of the family. Now, if a husband and wife own the business together, then we can still go back to the joint trust analysis. But when couples own businesses separately, it often makes sense to do separate trusts. Now, that is not an absolute. There have been many instances where I have done a joint trust for people who individually own their own businesses. But today, there are different advantages that we can take advantage of if we do individual trusts. Now, pros and cons of individual trusts are, pros are that we have more flexibility in our planning. Con is it requires more work, more expense, and does not mimic well the relationship typically between a husband and wife. Also, in our physician analysis earlier, if the physician has his own trust and he is the grantor, the trustee, and the beneficiary, which are the three main elements of a trust, and it's an individual trust, then the physician can own his practice or the shares of his practice in his medical corporation by his trust. So that's a benefit. I shouldn't say his or her. You understand that in this discussion here, everything I say is and supposed to be taken gender neutral. So let's talk about investments that entrepreneurs should consider. So there are, again, I am not a financial planner and I don't do investment counseling, but this is what I know about a lot of small business owners. They don't have the ability typically to take advantage of some things that bigger corporations have, such as 401ks, group health insurance, and things of that nature. The true small business owner, the administrative cost of these types of programs tend to be cost prohibitive. So things that I have seen small business owners do is open annuities or SEP programs or other vehicles that you put money into and produce an income stream later. And these are extremely valuable when planning your estate. We need to, when planning your estate, you want to look at not only to whom is your assets going to go when you die, and are they going to go efficiently? Are they going to avoid probate? Are they going to, is your estate set up in a manner that if there's some unintentional deaths in your family, meaning children die before parents die. These are unplanned, unintended results. And so is your estate set up in a way that if these unintended results occur, then your estate gets still administered in a cost-effective way and benefits the people you want to benefit. And the small business owner really needs to focus on these things because in most families, if husband or wife owns a family business, they usually can look at their children and say, one of the children is interested in the business that I own and the other one is not. So planning appropriately to who is going to take over that business when you die is very important. That translates very clearly into your estate plan and how we draft it, because we don't want to leave your business to both your daughter and your son if your son really has no interest in the business and your daughter is really the heir apparent to your business. So these are discussions we need to have. We need to look at the type of entity that you own your business in, corporation or limited liability company, sole proprietor, partnership, etc. And we need to plan accordingly so that when you die, the business transfers quickly, it avoids probate, it has low cost of administration. And again, not to beat a dead horse, but living trusts are the necessary vehicle most of the time to accomplish these goals. So how can you ensure that you're working with a qualified estate planning lawyer? Well, that's super simple. You have taken the last, I don't know, X number of minutes, 24 minutes and 6 seconds to be exact, to listen to everything I've had to say. If you meet with an estate planning lawyer that intelligently talks about the items that I have raised here and focuses on solutions that are consistent with what I've said so far, then you know you are working with a good estate planning lawyer. If your estate planning lawyer you're meeting with kind of rolls their eyes and has no idea what the appropriate way, and more importantly, not only the appropriate way, but why it is they should be doing what they're doing to help you with your small business and your estate. If they cannot do that, then my recommendation is that you shop for another lawyer. So let's do a quick recap. Let's answer some questions and let's call it a day. How about that? So my name is Christopher Nudo, and I am the founding partner of my law firm. And we focus on estate planning, real estate, and small businesses. We are located in Illinois, and we serve the Chicago community, include with offices in Arlington Heights and Elgin. Our topic that we've been talking about for the last 25 minutes is how entrepreneurs and business owners can structure their estate plan. If you missed our last session, I encourage you to watch the video right here on Facebook. This is where I explained how parents with children from two different marriages can handle the distribution of their assets. So if you have children from two different marriages, it might interest you to go back and watch that program. An overview for anyone unfamiliar with the benefits of estate plan. Here we share tips and legal guidance for parents, guardians, and other professionals. And we welcome you here every Friday that we broadcast live. So, we have a number of questions. Lots of people have joined us this morning, and we're just going to take the see how many questions we can get done here in a little short period of time, and then we can all enjoy the rest of our day. So, good first question. I've started a business. When is it really time to start thinking about estate planning? That's a very simple answer. As soon as you have the money to not only run your business, but think about what happens if you die, what happens to the business, that is the time to meet with a good estate planning lawyer, because you don't want to wait too long and run the risk of dying. And you've taken a lot of time, energy, and money to get this business up and running, and then you failed to plan effectively, and you die and your business ends up as a probate asset in Illinois. That would be a shame. So the moment that your business is up, running, and you're not feeling the incredible drain of the business, but yet you're making money, that's the time to sit down with an estate planning lawyer and get this done. If I am barely paying myself, should I really worry about creating a will? That's a great question. So, when people start their own business, it always costs more money than you're making. But if you plan and do well and create a good business, eventually the tide turns and the business pays you. And if your business is paying you, that means it is a positive asset that potentially could be sold. And so the answer is yes. Now, there are instances where your business isn't really a business, but rather a glorified hobby. And we really need to analyze what you're doing. And if you were to disappear off the face of the earth because you have died, what would be the consequence of that as it relates to your business? And that analysis will tell us whether or not it is a good idea for you to do your estate plan. But let's remember that doing your estate plan could have nothing to do with your business, and it could have everything to do with everything else in your life, such as you have small children and you need to care for them in the event you die, regardless of whether or not your business is barely paying you. So as you can see, we need to take a real holistic approach and decide when is and what is the right estate plan for you. How can I protect the ownership of my company when I get married? Well, boy, that is a loaded question, isn't it? And we're not going to dive into probably the dark crevices of that question, but I kind of understand it. And this is where I always say, if you're coming to a marriage and you already have your business established and you want to keep it separate, wonderful. Let's do individual trust estate planning, where we create a bucket, a trust that's just for you, and that's what controls and owns your business. Thereby, you can dictate exactly what happens to your business when you die, regardless of your spouse. So you and your spouse are maintain your assets separately. And now that not all of your assets have to be maintained separately. If you just want to keep the business separate, fantastic. And again, that goes back to our conversation we had earlier about how is your business owned? Is it a corporation, a limited liability company, partnership, sole proprietorship, etc.? And then the nuances of the type of business structure will dictate how best your individual trust interfaces with your business. Excellent question. Thank you. All right. Next. Is it better to have a separate corporation that owns my real estate assets? Good question. Can I, if you don't mind, please forgive me. I am going to rephrase your question. The question should be, should individual entities own real estate as it interfaces with my trust? The answer is yes, 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 yes. I say this all the time. If you are a real estate investor, I advise that each piece of real estate that you own is owned by a separate limited liability company, not a corporation, a limited liability company. And that will properly give you all of the benefits of expensing your expenses for tax purposes. It'll give you the benefit of limited protection through the limited liability company. And when we make your trust, your individual trust or joint trust, depending on if these are husband and wife investments or individual investments, the owner of the limited liability companies, we have done a wonderful job. We have ensured that your investments will transfer appropriately quickly. They will avoid probate, and the administration will be very inexpensive when you die. This is what I consider to be the proper planning for the real estate investor. How much does it cost to work with an estate planning lawyer? You know, costs vary. And what I would say is this, simple wills for simple people, where we don't have to be concerned with probate and we don't have to be concerned with guardianship, is going to be a lesser form of estate planning. The typical estate plan with a will is a will, a healthcare power of attorney, a durable power of attorney, and sometimes a document called a transfer on death instrument, which addresses the principal residence real estate in the family. However, most people will do living trust estate plans. And today, the living trust estate plan for a husband and wife varies between $3,000 and $4,000 for the average family. It does go up from there for families that have more wealth. But the living trust estate plan really is designed to make sure that your estate stays out of probate. We avoid guardianship in the event of incapacity of one or both of the husband and wife. We make sure that proper health directives and property directives, known as healthcare and property powers of attorney, are part of the plan. And this is the most typical way most estates are planned today. So what is really the difference between working with a lawyer and doing it yourself? Well, if you're working with a good estate planning lawyer, the benefits are, number one, you'll be receiving excellent documentation that is 100% appropriate for your circumstances, and you have the assurance of knowing that. Also, a good estate planning lawyer has knowledge of you as an entrepreneur and all of the different endeavors you're involved in. He or she, attorney, is able to intertwine your business life into your estate planning properly. Sure, can you do it yourself? Maybe, but what assurance do you have that when you do it yourself, you've done it thoroughly and appropriately? And so, if you're an entrepreneur, my suggestion is you stick to the business creation, running, and development that you have been gifted those talents with, and that you hire a good estate planning lawyer to bring that all together for your ultimate estate plan. All right. So do you offer virtual appointments or on-site visits? The answer is yes. We do everything. So you can come to us in Elgin or Arlington Heights. We can set up a virtual meeting, and we do that with like Microsoft Teams. We do it with, we're going to start doing Google Meets here in the future. We're just going to be available as you're available. Can I come to you? Well, sure, I can come to you. If it's appropriate and if it makes sense, I get in my car and I come to you. Sometimes I say it's easier for me to come to you than for you to come to me. But again, that's very fact specific and circumstance specific, but know that that is available. Finally, where can I contact you to set up a consultation? Well, here, right on my screen, boom. Look at that. Call me, text me. I always say to people, send me smoke signals. I really don't know if I could read them, but I think it would be pretty cool if somebody tried. They'd be like, did you get my message? I was like, how's that? Well, I lit a fire. I don't know. I think it works. I don't know. Anyway, but use the phone numbers. They're more effective than smoke signals. Richard will answer the phone. He'll help you. He is super smart and intelligent, and he will make sure that we can assist you in every way possible. There's also, I think my addresses are available, my email, all of that stuff. You can take that stuff down. It'll also be somewhere in the Facebook information. So listen, it's been awesome being here with you this morning. Hope you took away some little nuggets. It's always my goal to just leave the day with you knowing more than you started with. So you just have a fantastic day. God bless. See you next week.